Now, do you have copies of the subpoena applications for
Yes,
these
Senator, I can't discuss anything regarding this.
You can't even tell me if you have copies?
I can't discuss any of this.
All right, when are you going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator. This
but
was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay?
If a prosecutor can access the phone records of 8 sitting senators without a judge's approval, how safe is your privacy? Today, we are examining these limits of authority at the highest levels of government and Senator Kennedy's striking questions. Senator John Kennedy was waiting for his turn. Then, when he leaned into the microphone, he didn't start with a speech. He started with a hypothetical.
Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone companies. Let's single out AT&T, and I say, look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator. They're not going to just give them to me, are they?
Bondi did not hesitate. Of course, they wouldn't just hand them over. Kennedy nodded as if that was exactly the answer he expected. In fact, he said, the phone company would probably want to know what planet I had parachuted in from. Bondi confirmed this. They would tell him to come back with a subpoena. That much was obvious. That much was clear. In fact, this dialogue provides very important clues about what is happening behind the scenes of the system. But Kennedy wasn't interested in the obvious part. He was interested in what happened after the subpoena. How do you get a judge's approval to pull the phone records of a sitting U.S. senator? What exactly needs to be shown? He paused on this phrase, a sitting United States senator. He wanted this emphasis to hang in the air. Bondi said the answer was probable cause. Probable cause was needed to issue a standard subpoena to force a phone company to provide records. Kennedy did not respond to this answer, and then asked the next question. Would a judge need to approve it? Yes, said Bondi. A judge would need to approve it. Kennedy didn't rush this. He pointed out that phone companies, especially general counsels, have concerns about actual civil liability. Even if a properly signed subpoena arrives, a diligent general counsel can look at what is being requested and decide to challenge it. They have the right to move to quash this subpoena. Kennedy was clear about this, and a smart general counsel seeing a request for the phone records of a sitting U.S. senator could reasonably pick up the phone and notify that senator, do you want to be involved in this? Do you want me to object to this? The emphasis here points to that critical point we are all curious about. Bondi admitted that things got complicated here. If investigators believed a crime might have been committed, they couldn't notify the person who might be involved. The legal framework prevented such a warning. Bondi could not comment on the details of the actual case underlying this whole conversation, but she understood what Kennedy was trying to do. Actually, Kennedy wasn't speaking hypothetically. Not exactly. The day before, the FBI had revealed that the previous administration had conducted an operation called Arctic Frost to monitor and gather intelligence on Republican senators, and that several of the committee members sitting in that room were also targeted. Kennedy was one of them. Kennedy continued the pressure. A phone company's general counsel receives a subpoena for the records of a sitting U.S. senator. The general counsel, as any reasonable person would, takes the situation seriously and advises company management. This is a serious situation. This is truly an extraordinary situation. You can file a motion to quash. The company has this right. They can object for cause. Bondi confirmed this. Hypothetically, yes, they can object. Subpoenas are regularly challenged, and phone companies working with their general counsels sometimes don't back down. Well, what if they don't object? Kennedy asked. What if a reasonable general counsel, faced with a subpoena requesting the records of a sitting senator, just hands over the records without filing any motion to quash? What would this mean in terms of civil liability? As citizens, the most fundamental thing we need to know is who is actually behind these decisions. Bondi carefully noted that phone companies typically comply with subpoenas issued through proper legal channels. When a federal prosecutor presents a subpoena, companies usually comply. However, Bondi acknowledged the underlying key point. They don't have to. They can object. Kennedy calmly confirmed this. But under this deadpan expression lay a serious set of questions. Kennedy returned to the subject. He wanted to know if Bondi had copies of the subpoena applications used to obtain the records of 8 senators. The number 8 was constantly repeated in the dialogue. Not 1 senator, exactly 8 senators. Bondi told him she couldn't discuss anything related to this case. Not the applications, not the details, nor any other questions. There was the possibility of an ongoing investigation, and she could neither confirm nor deny its existence. Kennedy said he understood. He understood the constraints. But he was worried about something else. He didn't want it to be hidden. He had seen things swept under the rug before, and if there was an ongoing investigation into how the phone records of 8 sitting U.S. senators were pulled, he demanded that it be followed to the end. Bondi listened to all this. When Kennedy asked if a special counsel under his authority should be told to seek a subpoena against sitting senators, Bondi said she believed so. Both she and the FBI director had learned the full extent of this very recently. Details were still being gathered. Kennedy changed his question. He asked if the FBI director at the time, Christopher Wray, should have been informed. The questions being asked here are exactly the kind that any common-sense American would want to ask. If a special counsel was after a senator's phone records and needed the FBI to execute those subpoenas, that was something a director needed to know. Bondi said she believed that, in general, the FBI would assist in executing subpoenas served on businesses. This was standard procedure. But Kennedy's point wasn't about procedure.
If I were your special counsel and you had appointed me, and I wanted to get the records of a sitting United States senator, is that something you would expect me to tell you as Attorney General of the United States?
They better have.
Yeah.
And
Do we know in this instance of the 8 sitting United States senators if they told Attorney General Garland?
Senator, I just learned about this very recently, as did Director Patel, and we cannot discuss the details. I don't know many of the details.
Well, maybe we ought to get Attorney General Garland here.
Kennedy left this file open for now and moved on to a second, perhaps more shocking topic. This time, his target was Commerce Secretary Lutnick's statements, and he expressed this with the same calmness. Commerce Secretary Lutnick had given an interview to the New York Post on October 1st. Kennedy wanted to know if Bondi had reviewed the transcript of this interview. She hadn't reviewed the entire transcript, but she had seen a clip of it. Kennedy went over what Lutnick said. The Commerce Secretary, who lived in townhouses next to Jeffrey Epstein and shared a common wall between the 2 properties, had described the subject in specific and striking terms in the interview. When a reporter asked how other prominent men could associate with him, even though Lutnick himself immediately recognized what he described as the individual's character, Lutnick said those others didn't just fail to notice. He suggested they were part of these dynamics as well. He went on to describe what he believed was the specific methodology, a pattern of behavior he believed was recorded in private settings, and suggested that this recording was the basis of what Lutnick called a blackmail operation. In the interview, he called him the greatest blackmailer of all time and said that was the source of his money. Kennedy noted that this was the U.S. Secretary of Commerce and that the interview was published by the New York Post. He asked Bondi directly, "Is this true?" Bondi referred to the July memo released by the Department of Justice. That memo stated that investigators had not found evidence of what is commonly referred to as a client list. The case had gone through 3 separate administrations and multiple U.S. attorneys. That was her answer. Kennedy accepted all this. He knew the history of the case. He was not challenging the conclusions of the memo. His question was a bit different. It was specifically about the Secretary of Commerce. Had Bondi met with Howard Lutnick? No, she said. Was she planning to meet? Bondi said that if Lutnick wanted to talk to the FBI and the FBI director wanted to talk to him, that was certainly something that could move forward. Regardless of our political views, honesty and transparency are what we all expect. Kennedy pushed the issue. After such an interview in which a cabinet secretary described Epstein as a blackmailer who recorded people and built a financial empire on blackmail, didn't Bondi think it would be beneficial to proactively make that call instead of waiting for Lutnick to volunteer? Bondi said that if Lutnick wanted to talk to the FBI and the director wanted that meeting, it would happen. She stuck to this framework. Kennedy, addressing half to Bondi and half to the committee chairman, suggested that perhaps Lutnick should be brought in to speak directly to the committee. He floated this idea and then looked at the files in front of him again. Kennedy had come with very clear questions and asked each of them in order, out loud, in public, and on the record. Bondi could not confirm or deny an ongoing investigation. She accepted the legal standards Kennedy set out. She confirmed that proper notification throughout the chain of command was something she would expect from any special counsel working under her authority. She said she had learned all the details herself very recently, and in the Lutnick matter, she kept the door open without walking through it herself. Kennedy never raised his voice. He asked his questions in the same tone. The phone records of 8 senators had been pulled. The chain of command stretched up to the FBI director and the attorney general. And the people sitting at the top of this chain were now gone from their posts, while the current attorney general sat in a hearing room being asked to explain what happened and what would happen next. Bondi had told him directly. They were determined to look into all aspects of this. She had spoken at length with the FBI director about this. There would be a thorough investigation. No one wanted this pushed aside. Kennedy didn't want this covered up. Rather than complex and indirect explanations, the public needs direct and clear answers. I'm curious about your thoughts on this. What do you think is the main detail overlooked in this process? Don't forget to write your comments below because I will read them all one by one. Don't forget to subscribe to my channel for new videos every day and turn on notifications. The American people deserve the best.